Welcome. Very pleased to present the last of our COVID-19 series. This is the 10th one we've done. And today, I'm excited to have with me the managing partner of our Connecticut office, Theresa Guertin, the managing partner of our Southern California office, Jeremiah Welch, and our Southeast office managing partner, Greg Podolak. We're going to do the SDV Partner Roundtable, kind of musing on some of the issues that have already been touched upon, but maybe a little bit more strategically look at how COVID-19 plays out for businesses and their insurance coverages. And to start this, and I'm Tracy Saxe, the president of the law firm. So I'm going to start this off, just pass it out to you, Theresa, if you can just talk about what we're seeing with and doing with the clients so far since this COVID-19 outbreak began.
Sure. So when this all first started, we fielded a lot of calls from clients all across the country and in many different industries looking for early guidance and advice on what they should do, notifying their insurance carriers, tracking their losses and such. So we spent a significant amount of time on that at first. We're really still, even though we're a few months into this, in the early stages of evaluating coverage for these types of losses. There's a lot of complexity to the policies and to interpreting them for this these types of losses. And because there's so many potential challenges to getting coverage, a lot of our clients aren't really rushing to file litigation just yet. They're, I think rightfully so, doing a cost-benefit analysis first to determine if litigation is actually going to be worthwhile. And to make that decision, they have to know really quantifiably what their losses are. So, we've been looking at different cases and saying, okay, well, if you have a 40% chance to prevail, it matters if that 40% chance is to recover $50 million or $1 million. And a company might have a different appetite for that, depending on the loss. So, we're hearing that in those cases that have gone to litigation, the insurers are pushing some of those very hard. But mostly they're pushing the ones where they know that the attorneys involved don't really know coverage. But they're pumping the brakes on those where they have, legacy or top tier clients, or where they are being handled by firms that really understand coverage. So there's a little bit of a wait and see as well, because we expect there's going to be plenty of litigation in the next few years over this.
So Greg, what are your thoughts?
Yeah, so I think part of the value of doing a roundtable like this, and I'm so glad this is the format we chose, because I think it's a great opportunity to talk about what we're seeing and talking about with our clients day in and day out, which is really a lot of the questions that I'm getting from people nowadays. And it's such a unique landscape. This is kind of one of the overarching comments I give to people routinely, regardless of what particular issue we may be tackling in a given conversation, that you really need to keep in mind that the standard rules of engagement don't really apply nowadays. I mean, we're talking about the litigation that's ongoing right now, and a lot of people making a decision about whether they want to wade into that quagmire or if they want to wait and see how it develops. And we're talking about, thanks to the diligent efforts of our business development team, I can tell you close to 700 cases nationwide. So there is really, I think, in the near future, hard to say exactly how near, going to start to be some indication, as Theresa noted, of how most of these types of disputes are going to play out. And that's really going to inform, I think, how most conservative businesses decide how they want to proceed in engaging with their carriers, whether there's going to be a tidal wave of policyholder friendly outcomes or carrier friendly outcomes, and what they do with that. But it's a challenge, because I think for those that would instinctively say, I don't like the answer I'm getting, I'm not hearing good messages through my broker counterpart about how my carrier intends to treat this or treat me. It's where we might ordinarily advise that litigation is an appropriate avenue for potential recourse. That you have to recognize that the market is flooded with that right now. And so the kind of leverage you might otherwise expect to get is going to be very different. And it really requires some creative problem solving.
So Greg, staying with you for a moment, obviously there's a variety of different types of things going on out there, and there's also our business clients have all different types of policies. Where is most of the litigation, you think, going to end up? Under what types of policies?
Well, I think as we've seen now, those near 700 some odd cases really are largely focused on first party commercial property or business interruption driven policies. And there are some outliers, but for the most part, that is sort of the central dispute that has been, the thread throughout all of this, that in order for companies being financially impacted by what's happening, you have to demonstrate some sort of foundational direct physical loss. And we did a whole separate segment on this, which I would encourage the audience to go check out. It was a really great in-depth discussion about the various issues that come into play. But the dynamic comes down to a very sort of black and white view by both the carrier constituents and the policyholder constituents that is COVID-19, assuming you've got some basis to believe it's been around covered property, is that a direct physical loss? And the right answer is it depends. And this is where the creative problem solving and this strategy comes to bear on how individual clients should be proceeding, because some states have a very carrier friendly position. Some states have a very policyholder friendly position, and facts matter. What's going on in your individual case is really going to drive the strength of your ability to proceed effectively on one of these claims. So you really need to be looking for that cross section of strong, favorable law and a good set of facts to have the best options or the most options for how to proceed.
So, Jeremy, I'm going to turn to you and say, although maybe the bulk of our cases have been first-party property damage, business interruption, commercial property, or maybe builder's risk type of policies, we have seen other policies that are being triggered by these events. Could you maybe talk about at least one or two of those?
Sure. I think the one that probably has the most potential to help is a pollution policy. So any commercial pollution policy, whether you're a manufacturing facility, a construction company, hospitality business, you likely have a pollution policy. And that provides, these are manuscript forms, remember, but most of them have both a first and a third party component to them. The first party part is going to cover pollution liability. Now, in that world of pollution liability coverage, some of the policies are intended to cover a situation where you're somehow responsible for the release of a pollutant. And in that kind of a situation, you may be facing an uphill battle, because in reality, your first party loss is about the idea that you shut your business down because you were ordered to do so. Other policies are not written that way. They just simply cover damages you suffer because of a pollution event. And the pollution event is usually defined to include the activity of a pollutant. And pollutant can be very broadly defined. Some will expressly say that they include biological or pathological or infectious organisms. Others will just say contaminants or irritants. But when you're talking about coverage under a pollution policy, most courts have interpreted those kinds of terms sort of on the liberal end. And so the challenge could be that you'd still have a carrier saying, yeah, but you've got to prove that the virus was present on the premises. And that might be difficult to do. The one real advantage, I think, of these pollution policies, many of them have mitigation and rectification coverage. Patterned off the idea of a property policy that says if you board your windows up before the hurricane, we'll pay you to do that. It's the same thing with pollution. And so in the context of COVID-19, you've got a good argument under that mitigation coverage that costs of decontaminating the workplace, of buying PPE, of hiring a consultant to tell you the best way to handle all of that. And perhaps even in the construction industry, coverage for direct costs of shutting down a job site, demobilization cost. And so to me, the pollution policy represents probably the one of all the different policies in play that all have their issues, pollution's probably the most most closely tailored to the kind of thing we're talking about. And so maybe in that sense, the best hope of getting some coverage. I think it's important probably to right off the bat, we get a lot of people asking questions about liability. And I think it's important to remember there that first of all, we're not seeing a lot of that activity, but if you just think about it, the exposure there is the worker who gets sick for most businesses, right? Or member of the public. And so if it's your employee who is sick, first of all, that's probably a workers' comp claim. And so workers' comp is very broad, very, very liberal coverage. No reason to think that workers' comp isn't going to help you there. And then you've got employer's liability that stands behind workers' comp and says anything that's not paid by comp, we've got. So you've got workers' comp. But the idea that you then have members of the public, let's say, that sue you, that's your general liability policy. But remember, though, before going down that rabbit hole, the 99-point-something% of the potential plaintiffs that have bodily injury third-party claims against you are people who got sick, spent a few days in bed, maybe didn't go to work for a couple of weeks and then got better. Those claims are not worth a lot of money unless you can aggregate a large number of them. So a plaintiff's attorney might get interested if you were a meatpacking plant and you had hundreds of workers that got sick because you didn't decontaminate properly. But there's not many of those claims. The average business probably isn't going to face an onslaught of third-party liability claims. It's first party. And kind of dovetailing off what the other folks said, I think there's some wisdom in the idea of watching and waiting what other people are doing. Let somebody else spend the money litigating coverage and watch what happens, but be mindful. Many first-party policies have time to sue provisions, and they'll say things to the extent of, if you have a dispute with us over a claim, you've got to file that suit within a year of the loss. Not all states will enforce it that drastically. Some will say yes, but it has to be only a year from the time of disclaimer, but you got to know that. And so you can't be 2.5 years down the road trying to decide whether you want to file your claim, not realizing that you had a 1-year time to sue provision that's already passed. And on that thread about notice, if you're talking about pollution, some of those pollution policies are claims made. Any claims made policy that you think might apply, get your notice in before the next renewal date, because at renewal, they're certainly going to put a virus exclusion on the policy. The insurance industry really wasn't, with a small exception of people that wrote, policies tailored to contagion. The vast majority of lines of coverage weren't expecting this and are looking for ways to avoid covering it because it doesn't fit their underwriting model. So you can bet that at renewal, you're going to see very well drafted broad virus exclusions.
So Jeremiah, you're correct in saying that a lot of it's first party, that the third party liabilities may have limited damage, and if they're bodily injury claims, it's mostly going to be your employees, therefore workers' comp. But it occurs to me that maybe the wave we haven't seen yet is another wave coming about EPLI, which is there were a lot of people who were laid off, and how they bring people back and the recession that follows usually will just naturally lead to an EPLI increase, because people are going to claim it's based on that I'm part of a protected class. You brought back the younger workers. You didn't bring back the older workers. And you use the excuse because I'm more vulnerable or something else like that. So although that hasn't happened yet, because we're still in the midst of the wheel spinning, there is the recessionary and quarantine component of what's going on so far that may actually have its own impact. But it also occurs to me, a lot of things that both you and Greg talk about certainly are most directly affect our real estate clients and our construction clients, but we've got clients of all sorts. And I know, Theresa, for instance, if you could talk about some of the things that go on with our franchise clients, particularly those in the food service industry who have been very severely hit by this. Is there any special policies that they might be looking to that are beyond the first party property policies we've been talking about and pollution?
Yes, we've seen some really interesting and I'd say fairly new types of policies that we haven't worked with extensively before in connection with our franchise clients. They're called trade name restoration policies, and these became popular from the London markets after the sort of E. coli disaster that Chipotle dealt with, a few years ago, where they were unfortunately infecting a lot of their customers with E. coli in their burritos. And Lloyd's kind of stepped up and created a new product to provide reputational risk coverage to restaurants, franchisees, that sort of thing. And been looking at these coverages, and it's really interesting because, it's, like I said, it's a little different. There's a lot of defined terms, but generally speaking, they're covering accidental contamination or malicious contamination that occurs either at a restaurant or at a supplier's location. So, a lot of our franchise clients are probably experiencing significant business interruption losses due in large part to shutdown orders. But there's a possibility that they might be able to obtain coverage under these policies if their suppliers, as Jeremiah referenced, meatpacking plants, places like that where there's a lot of people packed all close together. If there's a COVID outbreak at one of those locations, this policy might respond. And what's interesting is that even though the science so far suggests that COVID doesn't spread through food, especially cooked food, the wording of the policies suggests that even suggested contamination might be enough to trigger the coverage, or fear of the contamination. And that seems like, something that might be very important for our franchise clients to look at.
And if I might just piggyback off that comment for a second, because I think that's such exceptional insight, and in large part because it highlights that something I think we all talk about with clients and colleagues. It seems like every day for the last 4 months, and that is you've got to not forget to look at individual circumstances. That individual industries have their own unique exposures and oftentimes unique insurance products that are tailored to the type of exposure and risk and concern that is foremost in their mind. And a lot of times it may be that manifests in a unique type of policy, a unique type of language choice within an otherwise standard looking policy, maybe even a very, let's call it unique in this context, fact pattern. And I think, sometimes it can be a little bit easy to slap the COVID label on something that's happening because that's what is impacting so many companies nowadays. But you look at someone that's sort of in food and beverage, and you think about maybe a standard commercial property policy. And I think to myself, if they're losing trade stock, stuff that is suffering physical damage because the environment around them is no longer capable of supporting that supply, I don't necessarily focus as much on the fact of whether it's infected or not. There is a physical loss to some covered property that's happening. And so I think people think, well, if this is COVID, I'm being impacted by COVID, and that's sort of the running narrative. Sometimes it's helpful to step back and sort of say, wait a second, this is the same basic type of loss I would experience any other day of the week. I shouldn't be swallowed up by, the sort of larger market that's having a COVID fight. And those nuances can make the difference.
So it's interesting, Greg. Talk about the idea that you've got all these individualized cases and their damages might be all different and they all need to be looked at specifically. I'm going to actually kind of kick this around both with you and with Jeremiah, and maybe I'll start with Jeremiah here. We've seen a lot of folks, we do nothing but insurance coverage. We've done this for years and years and years. We've seen people coming out of the woodwork, lots of lawyers doing cases, and particularly class actions, where they're grouping all of these cases together. Is that something that we recommend? Is that something that makes sense for these types of claims? And Jeremiah, let me start with you, and then Greg, I'd like to get your perspective here too.
Yeah, that's a tough question. And it's one a lot of our clients are asking. We've had clients, large and small, who've been approached by some of these outfits. And I think to me, if you're down on the lower end of the, spectrum in terms of size and market power as a business, small sole proprietorship or something, you may not have, you just physically may not be an option to hire your own coverage lawyer to go chase your own coverage. And so jumping on board a class action may be smart, may be the only play you have. But the best advice, I think, is to, if possible, have somebody who knows what they're talking about, figure out what your options actually are. We had a client the other day who said, I'm being approached by this class action. And I said, okay, it was a construction client. I said, is the class made up of all construction companies? I don't know. Okay, you don't have a virus exclusion in your property policy. Do you know if any of these other people do? I don't know. Okay, well, that's really important. Think about that. If you have a property policy that does not have a virus exclusion, and so the only battle you really are going to fight is this idea of direct physical loss. And I'd much rather fight that battle without a virus exclusion. And so you've got a decent claim there, or something to talk about. But everybody else in your class has these ironclad comprehensive virus exclusions. You're giving up, you're packaging your good claim along with a bunch of crummy claims. Those people that are just grabbing cases, like, hey, if you have business interruption, sign up for my class. 6 years from now, you get a check in the mail for $600. You're really not going to get your rights, handled the right way. If you have no other option, if you have an ironclad virus exclusion and a good lawyer tells you you got very little to work with, might as well jump on board. But other than that, you're looking at class actions that are narrowly tailored towards your type of business, towards the insurance company and the policy form that you're dealing with. And there have been some interesting ones. There have been some insurance companies that early on fired off position statements about their own policies that were completely wrong. Whether that was just bad advice given by somebody or whether they were trying to head off the masses, I don't know. But there are some companies that have put themselves in real tough spots by putting in writing some things that are just not correct. And there are a lot of states around the country with some pretty strong bad faith laws. So the point is you need to find some good advice about what your rights actually are before you decide.
So it's interesting. I'm going to turn this to Greg about, is there a right way to do a class actions, and can they be appropriate under the circumstance? But I want to just comment, Jeremiah. You talked about there were some early statements and responses to claims that were just plain wrong, had not really investigated or really looked at their policies. I would love for it to believe that it's purely a mistake, but it seemed like across the board, things were showing up in op-ed pages as well, that there was almost a concerted effort to tamp down claims, to make policyholders believe that they shouldn't even bother looking at their policies, don't bother filing a claim. And we don't know to what extent they succeeded, that those people who had potentially their policies had coverage, that they didn't press their claim.
I think before we get into, Greg, I know you've got some important insight there, but I think it bears reminding ourselves that however you connect to the insurance industry, whether you're a policyholder lawyer, an insurance lawyer, an insured, the insurance market, other than that very small band that writes pandemic coverage, did not price for this, did not anticipate it, did not plan for it, and never intended to cover it. Now, you can take their form and you can say, well, look, you wrote coverage that I can drive a semi-trailer through, and you're going to have to cover this claim. And that may be true, but it doesn't change the fact that the insurance industry probably didn't have this kind of thing in mind when they wrote your pollution policy, your property policy, your GL policy. And so it's probably true that if everybody that has COVID-19 related loss got a check for the value of that loss, the insurance industry would go under. And so, and I'm not advocating that somebody should not put in a claim because they feel sorry for the insurance industry. That's their job, right? But we have to approach this not as a bunch of zealots that say, if I have a loss, I deserve coverage. It has to be done carefully.
Yeah, so just to sort of round that out, it's important to recognize that the nature of the way insurance policies are written is that if you know that something bad is going to happen to you and it's obvious, you can't buy a policy for that. You actually buy your coverage for unknown risks. and the policies are written in such a way that they are very broad in their insuring agreement, and then they cut out those things that they do not want to cover under this policy. So it is actually the nature of the insurance business that when something like this, which is unknown, occurs, that the insurance company is going to take a hit for this, and they will probably fix it next time. We went through this. We've been all doing this long enough to remember that this all starts with asbestos. They didn't anticipate all this coverage, and they finally got asbestos exclusions on there, but they paid a lot of money. The same happened with the environmental. A lot of the environmental claims came out of a time period that was before there were any environmental laws. And so, of course, the policies didn't have exclusions, but no, the insurance industry did not expect that someday in the future, environmental laws would change and enormous amounts of money would have to be spent for cleanup. And they fought that very hard, but ultimately paid a lot of money for the cleanup of the environment. So all of this is true, and you're unfortunate, I suppose, as a policyholder who has to live through this tumult that's going to occur. And even those people some people might be bringing claims that are not well-founded, but well-founded claims are going to be fought very hard because of the economics, not necessarily because of policy language. And so persistence may make a big difference here. And Greg, I'm going to turn it over to you for comment here.
I want to echo that because I really think that Jeremiah's comment is incredibly insightful and really something that people should think about. And I agree with all of it. The challenge, of course, though, is that we're in an environment where more so than ever, the landscape is sort of stacked against, for the most part, against policyholders who don't have war chests to be able to survive these circumstances, who don't necessarily have the financial wherewithal to litigate until the ends of the earth to, if they have a viable claim on the merits of what their policy is. And I'd say, I think zealotry is a good word. I think you can't have these sort of, this bald approach to how the coverage should work, sort of just simply saying, well, it's business interruption coverage, it should be there. Like, it's not that simple. And you're right about the market conditions, but at the end of the day, I think what's the right tact is really, I like that word zealotry. It's not to be zealots, but it's, I think, to be, from our perspective, I think I speak for the firm as a whole, to be practical and reasonable about what the client's expectations should be based off of the policy they purchased, but then appropriately aggressive, because that landscape as it is right now is not going to favor stagnation. Now, that doesn't mean there's an easy answer. Yeah, go out and sue them. I don't know that that's going to create, any extra options like we talked about earlier. It's not like that's the magic answer. But I think some kind of aggressive conduct has to be considered for those people that have viable claims in order to fight that sort of overarching tidal wave that is working every day against them.
No, you're absolutely
Greg, you don't
right.
mind, go back to the sorry, were you saying something, Jeremiah?
Yeah, I think you're absolutely right, and I think the key there is that you have to have what you said about reasonable expectation. The insureds, and I do fear that with clickbait news and all of that it's hard for policyholders since this started to find good information about what their rights are, and there are plaintiff lawyers that are trying to sign people up without looking. Definitely without looking at their policies. And every single one of these people that talked to me that said they have been approached, every single one of them, it was true that they had not looked at their insurance policies.
It's funny. I've taken to, for the folks we're working at in the southern market, I sort of can sum it up for them and they understand in sort of one sentence. This is like the rest of the country is experiencing what we experience during hurricane season. That suddenly every lawyer who's a general practitioner, and I cast no aspersions based on these comments, but suddenly becomes an insurance coverage lawyer, even if that's not what they were doing the day before the hurricane hit. And so you suddenly get this influx of and wide disparity in experience levels, and that makes it incredibly difficult for a normal consumer to know what kind of advice they're getting.
Teresa's comment at the beginning is so insightful. This idea that insurance companies are actually mindful of the idea that okay, here's a case managed by let's say a sole practitioner who normally does wills and trusts, and there's not a lot of that work going on right now because of COVID-19. Hey, let's take some COVID-19 cases. The insurance company is going to push that case faster because it sees the opportunity to outmuscle that lawyer and actually get a good ruling on an issue that it knows it probably loses against an experienced coverage firm. That's scary.
Yeah,
Well, actually, I'll say go ahead, Theresa.
I was going to say, you know, what's interesting is it makes you wonder, are the insurance companies memorializing that decision somewhere? Because if there are claims handling instructions, push this case versus that case, you know, there could potentially be some bad faith there. And I think we would be, you know, in a good case, we might be looking to discover, you know, through written discovery and depositions, anything that's like that, because it does seem unfair in some ways.
Yeah.
Well, this may feed back where we were headed, still talking about class actions. We always have had a willingness to team up with other firms to add our insurance expertise and we work cooperatively with lots of different law firms all the time. This may be a situation where we have grave concerns that folks who are out there who are going to dabble in insurance coverage for the first time on some very complex issues may both choose bad cases, make the wrong argument, set precedent, which will not just hurt their own client, but will hurt our clients as well. And so that we've been very open, and one of the reasons we do these series, which are open to everybody, not just our clients, is we're trying to influence the way in which these are litigated. But let's go back to that with that idea in mind. What about class actions? Is there a right way to do them?
Yeah, I think the answer is yes. I mean, we've within the firm made it, you know, it's clear from all of this content, I think that we have been actively monitoring the landscape for almost the entire time now. And, you know, very concerned about exactly this phenomenon that we're talking about, which is that the influx of litigators of different experience levels with differing objectives wading into this debate and influencing the outcome for everybody. And even though we don't typically litigate class action cases, we sort of felt like this is really the primary opportunity to be involved in an appropriate way. And those cases can be managed properly. We're about to get involved in one that's we're involved in it. It's about to launch within the next couple of days. You know, but our objective as a firm, being very selective about who we're going to represent and where we're going to represent them, is all coming to bear on the strength of that case and the potential outcome, and really hoping to start to influence that broader landscape, even though it's not a typical environment for us. And I think the way to get into the meat of the question really is it on some level, the analysis, the strategy, the attention to detail, none of that changes. It's just a question of the forum in which that's litigated and recognizing the different dynamics that come to bear, but you don't treat the coverage issues any differently. You've got to understand the nuances of your case. You've got to understand the nuances of the law you're dealing with and the policy that's in front of you. Those really remain key to a successful outcome, and that's what we're trying to drive in that context.
This has been a great discussion, and we could probably do this for days, but I don't think that would make for a good webinar. So let's try and maybe, Theresa, I'm going to turn to you. How about some overall comments as we close this out?
Sure. You know, one thing, we've focused a lot today and in past webinars on first party coverage, I think rightfully so, because that is going to be the immediate, I think, policies that respond to this loss. But I think what's sad or unfortunate about the whole situation is that we really don't know what's coming. And there's a good chance that we could be dealing with COVID-related litigation for years or even decades into the future. A lot like, you know, the asbestos litigation that took place several decades ago. You know, I'm reading articles every day about medical, you know, professionals finding out these long-term effects of COVID-related infection. And, you know, Jeremiah, I think, mentioned earlier, those types of cases where someone gets sick and then they're fine to go back to work, that's not really a profitable case or a, you know, viable case to bring a lawsuit on. But what if, you know, we have millions of people across the country that have permanent lung damage? You know, these are things that are going to play out, I think, for a long time. And there might be a significant third-party coverage aspect to it, just not quite yet.
It does end up leading back to maybe the advice we always end up giving on every topic with insurance coverage. You should give your notice under your policy, because we don't know whether the case that looks like a $1,000 case doesn't become a $10 million case, because it turns out it wasn't just one person who got injured, and they're not just sick for a couple of days, they're sick for the rest of their lives, that it eventually eats into their livelihood, their ability to do their job, and then that's massively multiplied. You're going to greatly regret having a late notice forfeiture problem on the only coverage that might have been available to you had you give timely notice. So my recommendation is you need to ignore the propaganda. You need to look past some of the advice that is being filtered by the insurance companies, even through some of the less sophisticated brokers are out there, not necessarily are sending the insurance companies tamped down negative message, and look at your own policy, look at the unique provisions are there, look at your unique losses. In fact, I would just recommend we start backwards. Look first, if you've got major losses or potentially major losses or unknown losses in the future, you need to work backward and look at all the policies with those losses in mind and see where the coverage might be. And then make sure that you give your notices. If it turns out that you don't have the coverage or you don't have the losses you thought you had, nothing lost. But there's a tremendous amount lost if you don't at least look into it and give the initial notice. There may come a day there's complaints from the insurance industry that we're getting all these precautionary notices. Well, they could solve that problem. It's pretty easy. They just have to add to their policies an endorsement that says, we are not going to make you forfeit coverage if you fail to give timely notice because it's unknown at this time. Until they do so, you've got to give your notices.
And I just want to jump on that for a second, because it's such a great specific issue that we've seen manifest and a lot of people struggle with. I've got, how do I give notice? Let's take the construction industry as an example. The companies that have innumerable projects around the country, right? And they're trying to figure out, do I have to give individual notice on every policy for every project? And it becomes this sort of challenging process. Don't be afraid to have, all of that taken into account, don't be afraid to have conversations with your insurance company business partners, with your brokers about solutions. I think everybody on every side of this equation is trying to figure out how to proceed through this, and there's often no substitute for frank and open dialogue. I think just to pick up from there and give my sort of closing remark, I think similar to Theresa's comment, but maybe just a little more granular in one respect. I think it's really important from year to year now, as companies are sitting down and going through their annual process of renewals and looking at their program and really taking stock of what it means to have corporate risk in their space and how to finance that risk, that they need to be thinking very critically and kind of down to the basis levels about what that risk looks like today and how to define it. I think we went through this process in a certain way many years ago when cyber emerged much more on the foreground than it ever had before. And a lot of companies were saying, what does this mean to me? Do I go buy a cyber policy? It's much more challenging than that. You've got to think about, what the nature of the issue is, how it affects your particular constituents, the company at large, the individual members of the C-suite that may have some sort of perspective on this, and really come up with a specific definition of what that looks like for your company in order to understand how you finance that risk on a go-forward basis. And I'm advocating for people that they be thinking, now that they're sort of dealing with the fallout of this and getting to a place of normalcy, that advocating that they spend time thinking about that as we wade into the future, because it's going to be critical.
Well, thank you. I really think this was a great discussion. And again, as we always want to, we want to go on further and further, but this is a good time to close it out. And we appreciate everybody who has viewed this program, and thank you all.